on. If I understood your submissions correctly, does it mean that if there are allegations leveled against a minister or ministers, and those allegations, depending on their nature and severity, are serious, as in the instant case, the President has no option but to dismiss, and if down the line the allegations turn out to be false, he can, in his discretion, appoint or reappoint. It's that how I understood you.
That's not our submission.
Okay, put.
Our submission is this. If there are serious allegations made against a particular minister, then the President has discretion either to keep the person in the cabinet or to dismiss.
Yeah.
In exercising that discretion, the President will take into account whatever factors he so chooses in making that decision, such as the allegation is made by somebody who is a political opponent and therefore I'm going to ignore it. Or somebody who's a senior police officer, that's serious. As factors, that's for the President to decide. And he decides, it will never be the case that he has no option but to dismiss. So he has a wide discretion.
Mr. Cox,
Your mic is.
Let me repeat. Our submission is the President will always have a discretion to dismiss or not to dismiss. And the President will take into account whatever factors he deems appropriate for that decision-making process. And a factor could be, who is the author of the serious allegations? What are their nature? How does it affect Cabinet in general? And that's what the President will decide. How much time is there before now and the end of the next term of Cabinet? Let's say it's a week before Cabinet's due to expire. Should he take it into account, that fact? Yes or no? It's for the President to decide. It's now 2 years. When's the next national election? I think it's 2.5 years from now. It's a lengthy-ish period. So those are the kind of factors that the President will take into account, etc.
Now I don't understand you. The more you explain, the more it becomes so difficult for me to comprehend, because you're bringing personalities who would have complained, also the duration of the term of office of the minister.
Of the President.
Of the President.
Yes, of the President. Now, what I'm saying is this. The President is the person who decides whether to dismiss or not. And Justice Matopo, you put to me the question, is it the case that the President would have no option but to dismiss? And I said, no, he will always have an option to dismiss or not to dismiss. And the President is the person who decides what factors come into play in making that decision.
Sorry to interrupt. What factors, if any, would the President consider whether to dismiss or not to dismiss? Is that the inquiry?
That's the inquiry. Well, no, it's for the President to decide that question.
So if this President says, once the allegations were made against Minister Mkhunu, I underwent the same exercise that you are now alluding to. And in my discretion, decided that I'm giving him leave of absence. Forget about what it means. It's another area that we have to debate. Can a president do that?
No.
What is it that he cannot do?
Excuse me?
What is it that he cannot do then?
You can dismiss, or you can keep him. That's all you can do. That was my argument. It's black or white. There's a person who allegations have been made against, serious allegations or otherwise. The President will consider the charges, whatever they are, against the particular minister, and he'll decide. The Cabinet should continue to operate with this person or without this person.
And if he does not dismiss, as in this case,
then he can...
Then what?
Well, he can do a number of things. He can, if he decides not to dismiss the minister, say it's a Minister Mchunu in particular, he could, for example, under his powers in the chapter, assign different functions and powers to Minister Mchunu and have a different person take over the functions of the Minister of Police.
And what becomes of Minister Mchunu?
He goes-
Reshuffle him.
He goes to do tourism or home affairs or some other power or function. That's the point. He's still a member of cabinet. He's a member of cabinet and he's been assigned certain powers and functions.
So this is the interpretation that you'd contend we must read into.
91.2 read section 98, yes.
So it's too strained.
We say that any other alternative is too strained. This is the proper interpretation. This is not a post. We spoke about Masset.
No. The post we've moved away from it. We're talking about the position as a cabinet minister.
Absolutely.
Yeah. We are on one page there.
Yeah. So if
on your understanding, if the president had moved Minister Mchunu from his portfolio and maybe placed him as a minister of tourism and what, you wouldn't be here.
No. Well, we wouldn't be here for the reasons that we.
I mean, you for the second applicant.
No, I'm saying the second applicant wouldn't be here on the basis of why we're here today. Certainly not. No, we're here because he suspended him, not because he moved him or gave him leave of absence or whatever form of a substance. He suspended his functions, exercising his powers and functions as a member of cabinet. That's what he actually did, as opposed to suspended him from cabinet. And Justice Chiki, I think you touched on really the difficulty. Well, I'm not sure you spoke about it in respect of...
No, you're still addressing me.
Yes, but I'm coming back to your point. Is the Minister Mchunu, now that he's, let's call it suspended or leave of absence, however we call it, is he a member of cabinet today? That's the question. And if he is a member of cabinet, that's problematic for a whole range of reasons, because he sits in cabinet meetings on a Wednesday morning. That's problematic. Is he a member of cabinet or isn't he?
But he would be given leave of absence. So if leave of absence would mean he's not going to be attending any cabinet meetings in his place, if there's a new minister, the new minister would attend cabinet meetings.
Well, that's the point, Justice Matopo. Why would he be given leave of absence without dismissal? There's only one reason rationally that it could be, that he keeps his benefits. There's no other reason, because he's not exercising any powers or functions. None.
Can I tell you what my difficulty is?
Yes.
If the president were to act the way you suggest on allegations, I'm just worried that we could be plunging this country into some sort of a situation that is difficult to contemplate. Because if allegations were to be made by persons in the same caliber as Lieutenant Mkhwanazi, it means against maybe 5 or 10 cabinet ministers. It means on your construction, they have to either be reshuffled or sent home.
Justice Matopo, you've actually, with respect, you've actually hit the nail on the head. Let's assume there are 10 cabinet ministers who are fingered by the police commissioner, the provincial minister. Would all 10 be suspended and 2 new acting people come in? Or 20? Where does one draw the line? That's the problem. So it's worse if he has to, it's worse from you put it to me, Justice Matopo, we'd be in trouble if he had to do what I suggest is the way forward. I submit we'd be in serious trouble if he could do what he's done. That is, suspend when there are serious allegations made every single time it happens. That's exactly the point. I put it on reverse, jiu-jitsu. It's worse for the president if he has to do if he can do what he's done in the way that he's done it because there's serious allegations. Let's say tomorrow there's a serious allegation against Minister of Home Affairs. Tomorrow's Thursday, Friday suspends him, appoints an acting minister in Home Affairs. Monday, serious allegations against the Minister of Finance. Tuesday, suspension.
No, but it does not necessarily follow that if such a scenario were to present itself, the president always acts in terms of section 91.3c. He may or he may not. And 91.3C gives him not more than two persons.
Well, there's a debate as to whether those two. There's the simple proposition, and I'm not dealing with that for the moment. I'm talking about the question of suspension. Justice Motopo, you said to me, it would put the president and the country in a difficult position if every time there were serious allegations, the president couldn't suspend but would have to dismiss. I'm answering that question, that debate. And I'm putting the opposite proposition, that were the president be allowed to suspend every time there's serious allegations, you could have the whole cabinet suspended, effectively. I mean, you just think of it. The whole cabinet could be targeted by political opponents or serious people. And then the president said, well, I suspend the whole cabinet, they're all on gardening leave.
But the corollary is the whole cabinet could be dismissed.
Yes. And you get a new, that's what, he dissolves the cabinet, he gets
But then it's chaotic. Then on the interpretation that has been advanced by the respondents about leave of absence, suspension, one must accept that the president may have had a one-on-one with the minister.
Yes.
And try to ascertain, or ascertain his version.
Yes.
He would have to do that. And after that exercise, decided to say, okay, I'll put you on leave. Or the others could be, after that exercise, to say, let's put corrective measures, maybe.
There are no corrective measures when it comes to no post. There's no post. You don't put corrective measures. It's a simple question of, I'm the president, I want to work with these 10 people for the best interests of this country. That's how it works. It's not a corrective measure. That's the whole point. Maseta and all these cases, corrective measures where art is involved and et cetera, et cetera. This is not a corrective measure putting him on, let's call it suspension, leave of absence or whatever. This is to protect the integrity of cabinet, they say. Well, if you protect the integrity of cabinet, dismiss or not.
Okay.
That's the argument.
No, we've belabored it. That's
Mr. Katz, my questions are meant for Ms. Kofa.
Oh, yeah, okay.
Libakeng.
Well, unless Justice Mashalanta, maybe all the questions to me can be asked, and then I'll sit and...
Yeah, there are no questions for...
Are there no more questions for me?
No more questions.
As a president. Thank you.
Justice Chika, I'm bringing my laundry back, just in case I need to refer.
All right. Can I call you Ms. Libakeng?
Absolutely, Justice.
All right. I'm interested to know what you were saying is the alternative to the Commission of Inquiry. You were saying that instead of a Commission of Inquiry, then there could be individual investigations. Were you saying that? On the prosecutorship, on the magistracy, on the judiciary, and on all the implicated.
Justice Chiki, what I was trying to go into as far as that issue was concerned was to demonstrate the point that if the functions and machinery that rest under the police gets given to the Commission, that only seeks to demonstrate the usurpation of the powers that vest within the JSC as a body responsible for dealing with any issues affecting conduct of judges and so on. So my submission is not that the Commission is not appropriate. In fact, if I remember well, Mr. Mpofu used the words to say we need to draw a distinction between a judicial commission of inquiry and a commission, because simply.
Also, your complaint is the constitution of a judicial commission of inquiry, not the composition of a commission of inquiry.
No, absolutely. You've
okay. It now I understand you. Now I understand you. Thank you.
Thank you, Justice.
Now, on that point, if the concern is the appointment of a commission, the judicial commission, which is going to be headed by a judge, because you're saying the judiciary is implicated. And who's going to investigate the judiciary if it's an ordinary commission of inquiry, especially since the JSC and the Magistrates Commission is constituted of, amongst others, members of the judiciary?
Absolutely, Justice. Maybe let me break that question into two parts, because that's exactly what we are saying. Let me break that question into two parts. When the JSC sits to deal with any concerns relating to ill conduct, and however one can define it, on the part of the judges and or any member of the judiciary, it is because the people who would be sitting there to adjudicate would be the people who are not disqualified from adjudicating the dispute. The composition itself would be able to say, okay, there's an issue before the JSC. I mean, I do not foresee a situation where Justice, there would be a situation where Mr. Mpofu is the one who is sitting as the decision maker before the JSC, and he's investigating himself in the same instance. I believe that the same order of the workings of the JSC would take effect. Not that the JSC is not qualified; it absolutely is.
If any member of the JSC, in particular, members of the judiciary, who happen to be members of the JSC, are implicated, you are saying those will have to recuse themselves.
Absolutely.
And allow the remaining members to deal with whatever allegation that are there against the judiciary.
Absolutely, Justice. In fact, the truth is that even General Mkhwana's statement says some members of the judiciary. He doesn't say the entire judiciary is tainted. So I mean, to that effect, I would assume that in a situation where there has to be an inquiry into the conduct of judges, the composition that is legislated to give proper adjudication to those issues will be properly constituted. We do not want to take away at all from the roles and the functions of the JSC. We cannot do so.
Thank you. Mr. King, yes, you argue that the JSC is custom-built to deal with these type of matters, correct?
Yes, indeed, Justice Kolaka.
As I read the JSC Act, it seems that the common thread that runs through it is that it deals with complaints about the conduct of judges.
Indeed.
And it contemplates a complainant and a respondent,
Yes.
and it provides for the mechanisms then to deal with that. On any interpretation, what we have currently that's been put into the public domain by Lieutenant General Mkhwanazi is not a complaint about the conduct of judges. It's an allegation about corruption in the judiciary. So that's my first issue. And well, maybe you could just deal with that. Well, let me ask my second question because it's linked to that. Secondly, as I understand it, the terms of reference of the Commission, and I don't have it here, would not include making a finding of the kind a tribunal would make against any judge that, let's assume, is implicated in evidence before the Commission. It certainly seems to be compatible with how the two systems work for the report of the Commission to go before the JSC. And the JSC can then look at a complaint about the conduct of judges. So my question really is that these don't appear to be incompatible processes, and the one speaks to the other. And in any case, I'm not sure how on what is currently the allegations made, the JSC will, in terms of its own structure, be able to convert that into its complaints handling procedures. Thank you.
Thank you very much, Justice Kolopin. What we do in our heads of argument is to almost dissect, and I'm not going to quote directly from the terms of reference, Justice Kolopin, but what we do, we try to highlight the powers of the Commission, which include investigating, research, including amongst others, drafting reports and making recommendations. So we say, just on the first leg of the inquiry and the job of the Commission, it automatically overlaps. So we are not saying we should separate the two. We are saying there is an obvious Justice Kalapen. Let me take you to the letter, to the first letter. I think it's Annexure MK2 to the founding papers. If you'll indulge me, Justice Kalapen, I just want to refer you to the appropriate letter. There it is. Thank you. It is MK5 at page 47. Forgive me for that wrong reference. When we look at the content in this letter, what it simply seeks to do is to deal with the concerns that have been raised. First, yes, indeed, on the part of General Mkhwanazi and the implications there too. What we then do, and I would like to refer specifically to paragraph 3 and paragraph 4. And I'll not deal with the issue of the agency of the matter. It says the matter concerns the desired invalidation of events such as the assumption of office of the acting Minister of Police, which defect on 1. It is well accepted that the Constitutional Court is not ordinarily suited to hear agent applications. But no, I don't think this is the appropriate paragraph. Forgive me. Forgive me, Justice Kalapen. May I just hold this a minute for my colleague to help me with the actual reference of the paragraph. The CJ. Oh, yes. Okay. Forgive me, Justice Kalapen. The document we are supposed to refer to is MK2.
That's a statement by the President.
By the Chief Justice. That is MK1.
Yes.
That is at MK1, page 33. And Justice, I'm not going to repeat the answers because I've already read most of these extracts into the record. But I think the answer simply that I will refer Justice Kalapen to will be truly in the entire letter, paragraph 2, 3, and specifically the last part of paragraph 4. The last part of paragraph 4.
Okay. Oh, thank you. Just my last question. Are you saying that if anybody in complaining about public maladministration, could be the issue of healthcare, could be anything, refugees and asylum seekers, simply alleges that the corruption and maladministration extends into the judiciary, that on its own would be sufficient to preclude the President from appointing a judicial commission, just on that basis? That would be the consequence of your argument, not so?
Well, I think Justice Kalapen, I would not agree in those exact terms. What we are dealing with here is an actual statement relating to specific revelations and allegations made by General Mkhwanazi
against the judiciary,
amongst others.
No, let's look at it. It says these things that I've uncovered also reach the judiciary.
Indeed, Justice.
We don't know whether it's judges, we don't know whether it's magistrates, but he says it reaches there.
Yes.
But it's in the widest of terms. So someone could say that there's a tender fraud that involves members of the judiciary, and that would be sufficient just on its own. And I'm not suggesting that the judiciary should not be investigated. There are mechanisms and structures. But on your argument, that would preclude once and forever and for always the President from appointing a judicial commission.
That is why, Justice, we are saying we believe that the appointment of a judicial commission of inquiry ought to be done very carefully. I mean, otherwise we'll be having as many as we would have once there's an issue. They keep mounting and mounting. But what we're simply trying to demonstrate is that there are certain allegations that are made that are far removed, whose gravity may not warrant the establishment of a commission of inquiry. We take absolute notice of that. And we are saying when the circumstances so allow, and in this case, once again, Justice Kalapen, we're not saying, as I stated in my earlier submissions, we hold no issue with the composition of the Commission of Inquiry as established. What we are saying is there is a principle that says one may not be a judge in their own cause. And we are saying To that limited extent, the criticism of the establishment goes to that part.
Okay, thank you very much. Even though the JSC Act on which you rely violates that very principle, because the tribunal that exists would consist of 3 members, 2 of whom would be judges, investigating judges. Yeah.
That's the JSC, Justice Kolapin. That is the constitutionally mandated body to deal with those type of issues. And the only gripe I have here is to say, if there is a constitutionally recognized forum where certain acts and or misdemeanors ought to be investigated, that ought to rest within that organ. And we are saying to avoid not only duplication in costs, but duplication of the work itself, let the appropriate issue be addressed by the body constitutionally mandated to do so.
Thank you very much.
Thank you very much, Mrs. Kolapin. Thank you very much. Thank you.
Mr. Manager.
Thank you, Justice Mhlantla and Justice of the Court. I think my mic is on. Yes. Between me and my learned friend, Ms. Hofmeyr, we're going to share the submissions for the President. So I will deal with the merits, which is the 3 decisions, and Ms. Hofmeyr will address the jurisdictional questions. We propose to deal with our order slightly differently from how Mr. Katz and Ms. Lewaking dealt with their submissions. I will take the 20 minutes and then exhaust the submissions, take questions, and then leave the chance for Ms. Hofmeyr to take her 10 minutes and take all the questions and conclude our address.
We prefer to finish with the uninterrupted time.
As a court.
Let's hear you. Once your 30 minutes is done, we come in. We'll say we want you, then we will deal with you, and then at a later stage, if we have questions for Ms. Hofmeyr, she will come in and respond.
I will abide by that.
Thank you.
Thank you. Then I deal first with the first issue of powers that relate to, with the position of Minister Mchunu, and then I'll address the position of Professor Kachalia because they follow in logically, and then I'll deal with the issue of the Commission. On the question of the powers, firstly, in relation to Minister Mchunu, we have dealt with this at page 18 of our heads and following, and we commence our submissions by accepting the obvious, which is that the executive powers of the President in Section 91(2) of the Constitution do not include an express power to place a minister on leave or to suspend a minister. So there's no power expressly stated. But as everybody accepts, that is not the end of the inquiry. What we invite the court to determine, and which we will submit, is that there is an implied power that authorizes the President, either as a matter of substance in this case, to place Minister Mchunu on suspension for a period of time pending the outcome of a Judicial Commission of Inquiry, or as the President has used the phrasing, to place him on leave, which Minister Mchunu has accepted. So the distinction sought to be drawn between the request for special leave and being placed on special leave is much of a muchness because the Minister accepts being placed on special leave. We have referred, as all the other parties have done, to the Mabungani judgment of this court, which discusses the distinction between ancillary implied powers and primary implied powers. We rely primarily on ancillary implied powers, and we rely on the paragraphs in the judgment from paragraph 63 to 68, in which that judgment also references and relies upon the judgment in Masetla, at paragraph 68 of Masetla. So the contention of our learned friend, Mr. Mpofu, that Masetla is a different context, there was an employment, there was a post, is irrelevant to the extent that we're dealing with the question whether they are implied powers or not. The principle is the same. And the judgment in Amabungani at 63 to 68 indicates that the concept of ancillary implied powers and how it arises is formulated in different ways. Sometimes it's formulated as a power that is necessary for the proper exercise of the power, existing power, and that existing power can itself be an implied power or an express power, because it could be a primary implied power, or it could be a power implied because it is ancillary or incidental to the primary power, or its corollary. I always have difficulties with the R and the L's and which comes first, but or is the corollary of the power that is expressed. But in all those instances, what is clear is that it is a power that is either necessarily required for the proper exercise of the given power, or reasonably required, as Justice Colopin reminded us, but always it is for the proper exercise of the power that is given. And we will be submitting that to place Minister Mchunu on special leave is a power that is necessary or reasonably required for the proper exercise of the power to dismiss. And I'll come to why we say it is required for that proper exercise of that power. That's the first argument we make. The second argument is that one can derive the power by reference to the power to assign powers, and that's my secondary argument. The main argument derives from the power to dismiss. And the Section 91(2) in relation to the power to dismiss makes it very clear that it's the President may dismiss, emphasizing the discretionary nature of that power. Now, and it's a wide discretion, but as was said in Masetla and has been said in many cases, that a power conferred by the Constitution, the exercise of a power conferred by the Constitution is not unconstrained. So the power itself is not unconstrained. There are constraints to the power, and in this case the power to dismiss, and the constraint would be that it must be exercised lawfully, rationally, and in a manner consistent with the Constitution. Now, one asks, why would a power to place a minister on special leave or to suspend a minister pending the outcome of an investigation be a power necessary or reasonably required for the proper exercise of the power to dismiss? Is that there will be circumstances in which there are, as in this case, serious allegations which are made against a minister. And the President, as the minister testifies in his answering affidavit, engages the minister, and the minister denies the allegations. And the President says he is not in a position to decide, to exercise the discretion to dismiss without those allegations being investigated. And we would submit that that need for investigation in that context is to enable the President to discharge the power to dismiss in a manner that is consistent with the Constitution and the requirement of the principle of rationality. Because the principle of rationality requires that the process leading to the taking of the decision, in this case the dismissal of the minister, the process must itself be rational, because it must inform the President properly on whether there is a basis to dismiss. And the President says, I can't reach that decision lawfully, consistently with the Constitution, without giving the opportunity for those allegations, broad allegations, being investigated. And we submit that in that context, that power to place a minister on suspension or place him on leave in order to test wild allegations made in this sense is properly a power that is necessary for the proper exercise of the power to dismiss. In the absence of the implied power, it would mean that in every instance where there are serious allegations made, the President in truth has one option only. I know the the contention is the discretion is always there. But is a non-discretion when he can't take a decision in between keeping the minister or dismissing the minister. So if the allegations are so serious that they may result in the credibility of the cabinet being questioned, and keeping the minister is not justifiable, they say the only option is to dismiss. You can't allow for any in-between position. Our learned friend, Mr. Mpofu, seeing really the obvious difficulty with that argument, accepts that there must be an in-between, but the in-between cannot be a power to place on suspension or to place on special leave. And when pressed as to what the formulation would be of an in-between power other than, which would not permit of a power to place on leave, he can't, other than go into specific facts and say maybe in that fact, on those facts it may be necessary, but not on those facts, but not to formulate an objective rule that would be applicable from in different set of circumstances, because the existence of the power can't depend on facts. The power exists, it is the exercise of the power that may depend on facts, or whether on particular facts is necessary to place somebody on suspension or leave or not. And we submit for our learned friend Mr. Katz to say, well, if one accepts our proposition that absent the power, the implied power, the only option is to dismiss, and he says, well, on the other side, if you have the whole cabinet alleged of criminality, then you would end up suspending the entire cabinet. Our response to that is that neither of those propositions answer the question of powers. It's simply to illustrate really that it might be a difficult terrain when it comes to the actual exercise of the power, but it doesn't say the power doesn't exist because in certain circumstances it might result in the entire cabinet being dismissed. Obviously, in properly exercising the power to dismiss, the president would take into account whether dismissing the entire cabinet is the appropriate response or not. But that doesn't really answer the question of powers. And so we submit that on the principle in Masetra, this is a power that is reasonably required or necessary or ancillary really to the greater power as a lesser power to dismiss. That's the first source of the power. The second source of the implied power is to look at section 91 2, that the section doesn't only give the power to appoint and the power to dismiss. There is a power in between those two, which is the power to assign powers and functions to ministers. And you will see when read in conjunction with section 98 shows that the assignment of powers to specific ministers may be taken away on a temporary basis and assigned to other ministers also on a temporary basis, as in section 98. So here, what that shows, and we submit, is the power to assign, the power of the president, the express power to assign powers and functions, includes as a corollary to that power, the power to unassign the powers that have been assigned to a specific minister. And when the minister is unassigned, has no powers assigned or has been unassigned powers, that minister, as in this case, is excused from performing their functions or exercising their powers, as in being placed on leave, pending the outcome of an investigation. And in those circumstances, then their powers may, on a temporary basis, be assigned to another minister under Section 98, either an existing minister, such as in the case the assignment of those police powers and functions to Minister Mantashe to act in the interim, whilst Minister Kunu's powers have been suspended, so to speak, or unassigned for the temporary period, and he's at home on leave. Or, as I will get to, Professor Kachalia, where you might have somebody appointed from outside who then becomes a cabinet minister and is assigned temporarily those powers whilst the Minister Mkhunu is on leave. Both of those provisions we submit provide a basis to source the implied powers of the President to place the Minister on suspension or on leave. Both Section 91(2) in relation to the power to dismiss and the same section in relation to the power to sign and unassigned powers and functions from ministers. There was a question raised about, well, what about cabinet or ministerial accountability during Minister Mkhunu's leave of absence? During his leave of absence, he is excused from performing functions as a cabinet minister or exercising powers as a cabinet minister. Accountability to Parliament is for the exercise of powers and the performance of functions. If he's not performing functions and exercising powers, he is not also accounting to Parliament. He's excused by being placed on leave or on suspension. Then the next issue regarding Minister Mkhunu is the question of the lawful exercise of the power to place him on leave, which is the rationality challenge, really. They contend, the applicants, that that decision is irrational. But we remind the court, as it knows, that irrationality sets a very low threshold. It's quite easy to meet. All we need to show is that there is a rational connection between means and ends. And what the applicants try to do is to limit the President's reasons to those that he gave in the public address and say that anything that he adds in his answering affidavit is an ex post facto rationalization which is not permissible. But that's just wrong, because the application here is not a review. It's not a proceeding where the President was asked first to produce his reasons, which he declined to do, and now faced with a challenge tries to come up with new reasons. This is a direct challenge without offering the President an opportunity to provide reasons. And the President, facing a challenge, has given chapter and verse of his reasons for placing Minister Mkhunu on leave, pending the outcome of the Commission of Inquiry. And it's important just to go to the affidavit of the President to see what he says those reasons are. Because in addition to the reason that he gave, we're not running away from the reason given in the public address. That reason in the public address was to enable the Commission to perform its functions properly. Now, Minister Mkhunu sits at the heart of the agency that must be investigated. He is the Minister of Police. He's responsible for the police, and in his office there are staff members, there are documents which may be relevant to the Commission of Inquiry's investigation. In long dealing with precautionary suspension in the context of employment, it is proper governance in those circumstances to say, I'm taking you, allegedly the wrongdoer, out of your office so there is no opportunity to intimidate witnesses, either actively or just staff thinking the minister is still here, how do we cooperate with the Commission, or to make documents disappear, those sorts of things. So it's good governance to take him out, and it's justified. So that reason given in the public address is just as good on its own, but there are additional reasons that the President has given, and you will find that from page 85 of the bundle, I think that must be A, from paragraphs 42. He says, my decision in this case was informed by the seriousness of the allegations implicating Minister Mkhunu. Those allegations raise the question whether the Minister Mkhunu has breached his most basic duties under Section 96 of the Constitution, which include his duty to remain faithful to his oath of office. They also raise the question of whether Minister Mkhunu has engaged in criminal conduct. I therefore considered it necessary to remove Minister Mkhunu from his position, to take his current powers away from him, the point I was making about unassigning powers. Take the powers away from him, and to do so pending the outcome of an investigation into his conduct through the Commission of Inquiry. I also did not consider it appropriate for Minister Mkhunu to be moved to a different portfolio. He deals with the reshuffling, which they say was his option. He considered it. The seriousness of the allegations against Minister Mkhunu meant that he should not be exercising any powers while on suspension. The allegations have profound implications for public confidence in the executive and the police force as a whole. So I decided that a proper investigation into the veracity of the allegations was warranted. That is the height of rationality. It is not at all something that falls below rationality. The Old Book judgment, which our learned friends also referred to, say, it is not the function of the court to say you had a number of different options. The one you've chosen is not the most optimum. It is only to ask whether the one chosen bear any rational relation to the purpose that is given for that power, the power to place on suspension or to dismiss, to protect the integrity of cabinet, credibility of cabinet, to allow for proper investigations so that the truth is determined and an exercise of mind can be made by the President on whether or not to dismiss Minister Mkhunu ultimately. So that's the position of Minister Mkhunu. Then the position of Professor Kechelia. With respect, our learned friends, the court, in a different context, Justice Matopo asked my learned friend, but you seem to be placing all reliance on the President's speech. And he said, no. But indeed, it is the case. So there are...
Mr. Manager, you said you'll take 20 minutes and the 10 minutes
yes.
For your counsel.
Indeed.
I think your time is up now.
Yes, I appreciate that. Then when I come back, I'll start from the position.
Provide.
Thank you, Justice Mhlantla and Justices of the Court. As my learned friend, Mr. Maineche, indicated, I will be dealing broadly with jurisdictional issues. And in that regard, there are 3 topics I propose to cover. The first is to spend some time considering the underlying rationale and constitutional placement of Section 167(4) of the Constitution. The second will be to look at the pleaded case of the applicants for their asserted claim of exclusive jurisdiction in this matter. And then thirdly, to spend some time on Section 83B of the Constitution, which seems to be the last vestige of the applicant's case for exclusive jurisdiction, and to look more closely at what EFF1 said about that section. And then finally, time permitting, to deal with direct access. Justices, this matter does not fall within this court's exclusive jurisdiction. Very few matters do, and this is not one of them. This court has previously had occasion to consider Section 167(4) in the Constitution, and it has said that it must be narrowly and restrictively construed, and that is for essentially 3 reasons. The first reason is because cases that engage this court's exclusive jurisdiction come to this court first and last. No other court may opine on those issues. And there is a wealth of jurisprudence of this court recognizing how limiting that is in a situation where the court does not have the benefit of any other court's considerations of these weighty issues. And I would add to that, doesn't have the benefit of the refinement of legal argument and issue over time as matters wend their way through the courts. None of that is available to this court when it exercises its exclusive jurisdiction. And so that itself is a reason narrowly to interpret that provision. The second reason is because 167(4) of the Constitution is followed by 167(5) of the Constitution. And so it is critical to interpret sub 4 in the light of what sub 5 says. And if we could just turn to that for a moment. Today we're dealing with 167(4)(e). That one, the exclusive jurisdiction of this court, says only the Constitutional Court may decide that Parliament or the President has failed to fulfill a constitutional obligation. That's the one aspect of exclusive jurisdiction on which the applicants pin their case today.
But if we look immediately at what 1675 says, you will see there it is also concerned with conduct of the President. But there it deals with jurisdiction that this court shares with other courts. It says the Constitutional Court makes the final decision whether an Act of Parliament, a provincial act, or, and this is the emphasis, conduct of the President is constitutional, and it must confirm an order of invalidity made by the Supreme Court of Appeal, a High Court, or a court of similar status before that order has any force. What that means is that 1675 recognizes an appellate jurisdiction for this court in matters involving the conduct of the President. And if that is so, that is the express term of 1675, then when you are dealing with what 1674E covers, it must be something other than stock standard conduct of the President that is attacked for being irrational, biased, beyond his powers. It cannot be of that ilk, because that type of jurisdiction is a jurisdiction that this court shares with others, and in respect of which it is only exercising its appellate powers. And then the third element of this court's prior treatment of Section 1674 is to emphasize the special role that separation of powers plays when this court is exercising its exclusive jurisdiction. Those matters under 1674 engage the separation of powers in a different way to the way in which standard conduct of the President engages separation of powers. And what that means for this case is that you aren't in 1674E territory if all you're doing is complaining about the lawful exercise of the President's powers. On the contrary, you have to find a specific constitutional obligation placed on the President which has not been fulfilled in the given case. And Justices, this was not referenced in our heads of argument, but I'd like to draw the Court's attention to the recent judgment of this Court, penned by Justice Rogers in the Tembani decision, because at paragraph 101 of that judgment, Justice Rogers says, in essence, in summary, the point that I've been making to this Court until this point. There, the Court holds, exclusive jurisdiction is likewise not engaged where the President is said to have exercised some or other power in a manner which conflicts with constitutional principles, such as the rule of law, binding on all persons vested with public power. The essence of that reasoning with respect is that you cannot hook in this Court's exclusive jurisdiction if all the case is about is conduct of the President. And Justices, that takes me to the point of pleading, because there is no more than that as the pleaded case for this Court's jurisdiction in this matter. Justices, Justice Majid, in fact, took my learned friend to the 2 paragraphs in the founding affidavit where jurisdiction is addressed. They are only 2. They appear from page 9. They are paragraphs 13 and paragraph 14, and there is no identification there of a constitutional obligation specifically and primarily placed on the President, which it is alleged he has not fulfilled. All that these 2 sections talk about is conduct of the President and an allegation. It's not even an argument with respect, it is a statement that there will be argument in due course about why the case falls within the Nkandla and My Vote Counts cases. So as a matter of pleading, with respect, there is no case made out in the founding affidavit for this Court's exclusive jurisdiction. The final point is to remind this Court with respect about what was said in EFF 1 about Section 83B. The reason I must go there is because in the heads of argument of the applicants, eventually some effort is made to grapple with some foothold for the exclusive jurisdiction of this Court. The 2 paragraphs in the founding affidavit did not do it on any reasonable reading of those paragraphs. So now by the time the shoe pinches of heads of argument, vestige is taken in 83B. But Justices, as this Court recognised in EFF 1, 83B on its own is not enough to ground this Court's jurisdiction. It has to be coupled with a constitutional obligation in respect of which there is a failure. And as one will recall, in EFF 1, the constitutional hook there, the constitutional obligation specifically identified as not being fulfilled was the obligation of the President to act in accordance with the remedial action of the Public Protector. That was, in the words of this court, the primary obligation, in respect of which, when it was read with 83B, this court was satisfied it had exclusive jurisdiction. In this case, there is nothing beyond 83B, other than complaints about the conduct of the President. But as this court held in Tambani and has said in EFF, those are not cases which fall within this court's exclusive jurisdiction. They are cases that ought to start in the High Court because they are the standard basis upon which exercises of public power are attacked. Justices, if that were not so, the consequences for this court are very serious. Because cases of exclusive jurisdiction, this court can only determine. If this court in this judgment widens its jurisdictional ambit to take this case, it will likely mean, amongst other things, that all powers that are granted to the President under the Constitution, powers to assent to bills, powers to call for national referenda, to pardon offenders, to confer honours, will come here and only here as this court of first and final instance. And that would make a mockery of the prior jurisprudence of this court. Albert was a case dealing with the presidential pardon. It started in the High Court, appropriately. It came here on appeal. Man Singh was a case about the presidential conferral of the status of silk. That started in the High Court. It went to the Supreme Court of Appeal, and then it came here under 1675. And that is my time, Justices. I will deal with direct access if there are questions in my question session. Thank you.
I'm hoping for questions.
Oh, sir.
Justice Majid?
Yes, just on direct access. Now, the argument is that this is a matter of important national concern, which just as an ordinary citizen it is, but legally, why do you say that if we accept that there's no exclusive jurisdiction just for the moment, why do you say this case doesn't warrant direct access, given the fact that it goes to national security and that it implicates a wide range of actors, even the judiciary?
Justice, because many, many cases involve matters of grave constitutional significance. But our constitutional scheme says those start in the High Court. The High Court is where you go. The High Court moves urgently, more easily than this court does. This court sits on bank, and often with as many as 11 judges. The cut and thrust of the High Court is where you start those cases. You do it in the urgent court if you have a case for urgency, and you do it on matters of free-ranging constitutional significance. You don't get any lesser order out of those courts, but you get the benefit of a reasoned judgment from that court, and that judgment can only inure to the benefit of this court's ultimate consideration of the issue. So we don't deny that these are issues of public importance, but we say the constitutional scheme, because 1675 recognizes conduct of the President and challenges to it begins in the High Court, is where those cases start. So this court has the benefit of those initial judgments on the issue.
Just as a follow-up and a last question, much was made about the fact that Professor Kachalia is supposed to start on 1 August.
Yes.
Is there anything significant about that date?
Not at all, Justice Majid. Not at all. Any issues with with Professor Kachalia's appointment can be dealt with in due course, as this court has dealt with appointments such as that of Mr. Nkasane in the previous case thereafter. There's no magic in the fact that it will commence in 2 days.
The applicants raise a concern that if they were to have gone to the High Court, there would be a problem with time constraints. If one party is not happy with the outcome, the appeal processes, and there's a date, there's a deadline there, the 1 August issue. What do you say to that?
Justice McClellan, I've addressed the 1 August issue. In our submission, it is a non-issue because there are processes to deal with the irregular exercise of power thereafter, and there is a wide range of remedial option available to a court presented with the case. But if I can pick up on the point about cost, Justice McClellan, the answer is 1675. 1675 says these cases start in the High Court. They must, because this court must be approached in an appellate role after the benefit of lower courts dealing with these issues. The fact that a disgruntled litigant in the High Court might see fit to appeal can't undermine what the Constitution said about the very specific preserve of this court exercising exclusive jurisdiction. And Justice McClellan, if I can say it another way, if cost in the process of moving up the courts was a reason to invoke this court's exclusive jurisdiction, this court will never do anything other than exercise exclusive jurisdiction.
Can be in a position to approach the High Court and ask for the matter to be heard as a matter of urgency.
Absolutely. Justice McClellan, in essence, that goes back to Justice Theron's set of questions to my learned friend this morning. Of course, they can move, the High Court can be moved on the most hyper-urgent basis. The next morning, if the circumstances of that night, if the circumstances of the case warrant it. They could have gone there. Our argument is they ought to have gone there because they cannot come here under the court's exclusive jurisdiction. But we also say they cannot come here under direct access because all of those opportunities to get their interim order if they had a case for it, to get a proper ventilation of the vires, rationality, etc. aspects on which they attack the President's decision could have occupied the High Court, could have, and we'd say further, appropriately should have occupied the High Court.
Thanks, Ms. Hofmeyr. I understand and I appreciate, and which I have to accept, that the High Court can be approached as a matter of urgency, and so can the Supreme Court of Appeal. I'm asking this not on exclusive jurisdiction as such, and I'm not sure whether my question falls under direct access or urgency, because both are relevant in this matter. There's the urgency issue,
Indeed,
which is why we're in court today, and then there's direct access. I'm just worried that this proposed commission at the moment has been given a life of 6 months. And I'm just worried that even if the applicants can then approach the High Court and then Supreme Court of Appeal and then this court, whether they will be able, when they ultimately come here or to the Supreme Court of Appeal, to be in a situation where the commission is not complete. And because once the commission is complete, then the horse would have bolted.
Indeed. Justice Leakey, if the applicants have a good case for stopping the work of the commission in its tracks, they can bring that case. You can interdict, as a matter, conceptually, you can interdict the running of a commission if you have a good case for it and you get before a High Court on its urgent role and you convince that court that on the balance of convenience, there is such prejudice to the continuation of that commission of inquiry as compared with the consequences of permitting it to continue, that you obtain your interdict. That is conceptually available, and it is an answer to any allegation that down the line prejudice would already have occurred, horses will have bolted. But you have to have a good enough case. I would submit that case would be a difficult one to meet, but it is arguably available. The point for jurisdiction and direct access is you make that argument in the High Court. It's suited to it. You have to meet the requirements for interim interdicts if you are to get it. But if your case is overwhelming, and remember, the prejudice will only exist if the case is overwhelming, then you will get your interdict in the High Court, and you can prevent it running.
Ms. Hofmeyr, I accept that one might have to show irreparable harm if one was seeking an interim interdict in advance of a determination of the lawfulness of the President's decision to establish the Commission. But if the matter were litigated urgently on the merits in the High Court, and the High Court found that the President's decision was irrational or unlawful, and therefore declared the establishment of the Commission unconstitutional, we know that wouldn't take effect until confirmed
Indeed.
by this Court. But Section 172(2)(b) says that a court which makes an order of constitutional invalidity may grant a temporary interdict or other temporary relief pending a decision of the Constitutional Court on the validity. As I understand it, that would mean that after having found the establishment of the Commission unconstitutional and pending the decision of this Court, the High Court could interdict the Commission from operating.
Absolutely, it could.
Now, at that stage, what would the test be? Would it still be irreparable harm? Or given that the High Court had now done something within its jurisdiction to declare the Commission unconstitutional, what then would be the test? Would it be a matter of essentially just and equitable relief?
Justice Rogers, it's an extraordinarily interesting question in the scheme of Section 172's creation of powers for the courts. Because the determination would already have been made by the High Court that there is an unlawfulness in the making of the decision, that will create in our submission a weight on the side of the case in favour of potential suspension, and the governing test would be one of justice and equity, not the irreparable harm that ordinarily has to be achieved, where you are seeking the interdict first up and you don't have the weight of the court's already determination as to unlawfulness. Because remember, just to add to that point, when the interim interdict is sought, there is no final determination on the ultimate legal question. It is done at a prima facie level, which is why that, coupled with irreparable harm, is the right test for the interim interdict from the High Court. What we are postulating here is a situation where the High Court has already made the final merits decision. That, in our submission, means the test would move to a justice and equity determination.
Yes, because part of my concern with direct access, and I don't express any views to what should happen in this particular case, but one senses a contention that because it has to be confirmed by this court, nothing effective can happen until it reaches this court. And it would be dangerous for us to set a precedent which said that the High Court cannot stop things.
Certainly.
If it can deal with the merits urgently, it seems to me that if its finding of illegality in the establishment of the Commission is a finding it's made, then I would think that prima facie it should prevent the Commission from operating until this court makes a decision. But so with any other conduct that has to be confirmed.
So with any other conduct that must be confirmed, it cannot be so that having made that determination, the High Court closes its eyes because there is a provision of the Constitution requiring confirmation from the very real prejudice, assuming such a case can be made out in the interim.
Well, I mean, take the case of a provision in the Refugees Act, say it was amended to allow a deportation to happen.
Absolutely.
In circumstances that expose the deportee to prosecution in the return country. It seems unthinkable that the court, having declared the provision unconstitutional, would not interdict the government from acting on it pending confirmation.
Indeed, and what would no doubt weigh with it is this point, to go back to Justice Cheeky's question, of the ultimate impact of a period of time in which things run, right? If the prejudice is so overwhelming, having already made the determination on the merits, there could be no proper construct of this constitutional scheme that didn't give the High Court a power exercising the rubric of justice and equity to do something in the interim.
The argument perhaps against it is that, of course, the High Court might get the answer wrong and dismiss the application,
Yes, but that
and they wouldn't get their interim protection.
Indeed, but there are always risks in our system of wrong judgments. That fact shouldn't determine constitutional interpretation.
Thank you. Just briefly from my side, Ms. Hofmeyer, do you read Section 91 to create an obligation on the part of the President to appoint the Deputy President, ministers, and assign powers and functions to them?
No, we don't read it as an obligation.
Okay, because 91.1 defines the cabinet. Not so. It says the cabinet consists of the President, as head of the cabinet, Deputy President, and ministers. So how can the cabinet not come into existence if the President has no obligation to actually appoint the Deputy President and ministers and assign? Because if that is permissible only, then conceivably we could have no cabinet.
Well, it would require a reading of 91.1 that reads in the words that inform the discretion in 91.2. So the cabinet consists of the President as head of cabinet and such deputy president, the deputy president and such ministers as appointed by the President in terms of...
No, sure. My point is simply that the President doesn't have a discretion. He has to appoint the Deputy President, and he has to appoint at least 2 ministers.
Yes.
All we have is ministers in plural, not so.
Indeed.
But there's no limitation on. And so that's a constitutional obligation that the President has. Not so.
Yes, apologies, Justice Colopin. What I was answering was the question whether in all instances there is an obligation. I readily accept there has to be some constitution of a cabinet in its bare minimum, but not every instance of thereafter appointments, assignments of functions and dismissals is an obligation.
Sure. Now, the applicant's case is 83B, and they say that the President doesn't have the power to dismiss. And they argue that, well, their case for exclusive jurisdiction is then not solely premised on 83B, but on the President not fulfilling a constitutional obligation.
Yes.
And as I understand it, their argument is that the power to dismiss is not peremptory, but if the President elects not to dismiss, then he can't do anything else. Well, that wasn't Mr. Mpofu's argument, but certainly Mr. Katz's argument. Would that be sufficient to get them into exclusive jurisdiction?
Certainly not.
Why?
If I could deal with it in 2 parts. I think it's very important to understand, first of all, what the first applicant's argument is in relation to duty. Because, Justice Colopin, I listened carefully to my learned friend, Mr. Mpofu. Every time Mr. Mpofu goes to section 91.2 in the course of his argument, he uses the language of power. I took particular note. He talked about it being constitutional power bestowed on the President. He describes it as a prerogative power. He even went as far at a point to talk about it being in the gift of the President to give it. For as long as you are in the world of powers and are describing them in this way, you are describing quintessentially discretionary powers. And those are a far remove from the constitutional obligation, the failure to fulfill it, which engages this court's exclusive jurisdiction. So my first point, if I may, in response to Justice Colopin, is just to frame the first applicant's case is actually a case antithetical to this court's exclusive jurisdiction, because it is a case premised on a recognition of the, I think they even describe it as unfettered prerogative power, i.e. discretion on the part of the President. If I can then move to Mr. Katz's argument, which is more narrowed. In essence, Mr. Katz, as I understand for the second applicant, says, well, there are 2 options. You ping-pong either between dismiss or keep on. But even then, Justice Colopin, the only basis on which the exercise of the power in this case has been attacked is a vires point. That's Mr. Katz's argument, as I understand it. It's vires. He has 2 options only, and he did something in between. But questions about the vires nature of the exercise of a power by the President is stock standard conduct of the President that 1675 of the Constitution says goes to the High Court, and in respect of which this court only exercises appellate jurisdiction. So even on Mr. Katz's more narrowed argument for the second applicant, exclusive jurisdiction is just not engaged. They don't have that quintessentially constitutional obligation that implicates the separation of powers in a way different to ordinary conduct of the President to ground this case before this court.
Ms. Hofmeyer, something worries me. I hope you'll clarify it and put my mind at ease. You've had a debate with my brother Kolapen, Jay. Section 167(4)(e) talks about the president decide that the Constitution and this court may decide that Parliament or the President has failed to fulfill a constitutional obligation. Following the debate with my brother Kolapen Jay, you say the constitution of the cabinet by the President, is it a constitutional power or a constitutional obligation?
It is a constitutional power because he has a discretion to select who he appoints into those positions, what he does when
No,
he
let's start right at the beginning. For him to establish a cabinet,
Yes,
for assigning those powers,
yes.
is it a power or an obligation? Remember, the president is elected. After being elected, the president then sits and says, now I must constitute a cabinet.
Yes.
What is that? Is that a power or an obligation? The Constitution says, once president you are appointed, constitute a cabinet.
Yes. If I may answer it in two parts. As in my engagement with Justice Kolapen, 91(1) requires there to be at least a president, a deputy president, and a cabinet of 2 ministers. Right. That requirement may well invoke an obligation on the president. And were the president to fail to do that, because we are not in discretion territory, we are in obligation territory, it is conceivable that you have the type of constitutional obligation that Section 167(4)(e) is concerned with. But then we go on. Having done the bare minimum that 91(1) of the Constitution requires to have been done for there to be a functioning national executive, beyond that, the President is at large, unfettered, to continue to appoint more, to assign them particular functions, and to dismiss them when required. And we say amongst the exercise of that discretionary power to do things like suspend when there is good reason to do so. Those are not obligations placed on the President. Those are powers given to him. He exercises and must do subject to the strictures of the law. But when he fails to do them, you run to the High Court. You get the High Court to give you your remedy, including your interdict if you have a case, and you come up to this court only thereafter. It's not, if I can just emphasize, no part of our argument today for the President suggests that his conduct is immunized from attention and judicial scrutiny. The only question for the purposes of my argument is whether challenges to the way he exercises his power must come first and last here. And we say there is no reason for that to be the case in this set of circumstances.
Just bear with me. Let me look at my notes. So on exclusive jurisdiction, if I understand you, you would say this case, it's not about any obligation. It's about a disagreement of how the President exercises his powers.
Yes. And as is all other reviews of conduct of the President, of organs of state, every time a court sits in judgment of the vires, rationality, and alleged bias in decision-making, it is considering whether power was lawfully, constitutionally exercised. And we say that is no different in this case because it's conduct of the President in the exercise of a power that we are concerned with today.
I had expressed provisionally strong and firm views when
Yes.
when
I took note.
on direct access.
Yeah.
I'm not sure if I've moved or not. I don't take long to express my views.
I see that, Justice Matopo. I hope I've maybe just given you pause for thought at this stage.
You have.
Thank you, Justice.
So you reckon the public importance of the matter could have been entertained at the High Courts?
Certainly. There are manifold cases of great constitutional significance that appropriately start in the High Court. Justice Matopo, this court has said in its own judgments how its workload is crippling currently. The expansion of its jurisdiction means it is a court that should be engaged as a court of last resort, because that advances the administration of justice. Justice Matopo, there is such importance behind this point. The administration of justice requires this court to sit when it must sit and to deal with its extraordinary backlog that it currently faces. If this court can be the court that every litigant comes to when it alleges that there has been some irregular exercise of power by the president, all the other cases that legitimately must be here, the cases in which this court must sit as an appellate court, get shifted down the roll. And that, in our constitutional scheme, is reason to be very cautious, as this court said in EFF 1, about taking on. Former Chief Justice Mogoeng spoke about the monopoly power of this court. This court must be concerned about taking for it, as a court of first and last instance, cases that should come up to it from the high courts. There's a special preserve for this court. And unless it sets its limits in this case, we would say the administration of justice more broadly can be imperiled.
So if you are correct with your submissions on both, then it would mean that the applicants don't come home at all.
Correct.
And what would become of Professor Kachaila's appointment? He'll take office?
He will take office, and the reason...
And the commission will commence its...
Indeed. And that is the consequence, Justice Matopo, when litigants go before the wrong forum. It is just simply the consequence. If you go before the forum that didn't have jurisdiction, you suffer this consequence. These applicants put together the case for this court's jurisdiction in 2 paragraphs of their founding affidavit. 2 paragraphs. This is such an important issue, and they devoted 2 paragraphs to it. If they are wrong, they will suffer that election, that they came here instead of running to the High Court, giving much less notice, because that High Court can move itself more quickly than this court can, and deal with that forum.
Won't we be accused of ducking the issues?
Certainly not. On the contrary, Justice Matopo, with respect, this court will have properly set the limits of its exclusive jurisdiction, and that will inure to the benefit of this court's ongoing jurisprudence and its ability to manage what comes to it.
Okay, thank you.
Thank you, Justice Matopo. Thank you, Justice Mhlantla.
Mr. Manager,
Thank you, Justice.
my question is on the appointment of Professor Kashalia.
Yes.
In the answering affidavit of the President, I'm referring to paras 52, 55, and 57, page 90 and 91.
Yes.
The President has given different explanations. In para 52, let me wait for you to get there. Mr. Mpofu referred us to para 57, where the President said, I'm appointing Professor Kashalia as acting Minister of Police. I would like to take you to para 52 first.
52.
52.
Yes. Yes.
In para 52, he says, I'm entitled to appoint a minister from outside of the National Assembly in terms of section 91(3)(c) of the Constitution. my appointment of Professor Kashalia as a minister will be made in terms of this section. That's what he says at 52. Then at 55, he says, upon his appointment as a minister, I will assign, Professor Kashalia will be assigned Minister Kunu's powers and functions as acting minister. Then the confusion comes in at para 57, where he then says, I'm appointing him as acting minister in terms of section 93(1)(c).
Yes.
And we know you don't appoint an acting minister in terms of that section. It's a fully fledged minister. I think that's the argument about the
Yes.
applicant.
Yes,
Please clarify this.
that's right. So I'll give the court the structure of the affidavit, and which will show that the answer is consistent and is in line with the Constitution. There's a very innocent explanation for the sentence that our learned friends like very much, which says, where does it start? I have outlined above the reasons why, given the nature and seriousness of the allegations against Minister Mchunu, I have elected to appoint an acting Minister of Police from outside of Cabinet, as I'm entitled to do in terms of sections. You'll see sections 91(3)(c), and in the drafting, and 98 fell off. But I can't make the argument purely on the basis of something that is not in the affidavit. What I'd need to show to the court is, so firstly, Professor Kashalia has not been appointed minister yet, acting or otherwise. And there's a simple reason for that, and that will be found in section 96(2) of the Constitution and section 101 of the Constitution. So section 102 says, 96, members of the Cabinet and Deputy Ministers may not undertake any other paid work. And then 101 says, a decision by the President must be in writing if it is taken in terms of legislation or has legal consequences. And the President has explained that when he appoints ministers, he does so by way of a President Act, and he's attached an example in the affidavits. So the explanation of the President in the answering affidavit is that he will appoint Professor Kashalia when his term at Wits ends on the 31st of July and becomes available to take up a position as a cabinet minister, because then he doesn't have two salaries. And that appointment will be done in terms of 91(3)(c) as a minister from outside. And when he is appointed, he will assign him the powers of police to act in the place of Minister Mchunu. And that is evident from the affidavit, and I'm going to give the court the way the affidavit is structured so that that can be followed. You'll see from page 88, the President, under the heading, my decision to appoint Professor Kashalia as the acting minister. He starts off by referring to section 98. So he's aware of section 98. And then he says, 48, the placement of Minister Mchunu on a leave of absence created a lacuna in cabinet, leaving open the critical position of Minister of Police. It goes without saying that I was compelled to take the necessary step to address this lacuna. Then he talks about the allegations. Then at 51 he says, given the importance of the role of Minister of Police and the potential for the allegations made by Lieutenant General Mkhwanazi to undermine the legitimacy of our law enforcement structures, I deemed it appropriate to appoint a person from outside the existing cabinet to occupy the position of minister for the duration of Minister Mchunu's leave of absence. So that's a temporary duration. This would remove the possibility of the allegations pertaining to law enforcement officials from tainting or being perceived to taint the South African police and other agencies. 52. I'm entitled to appoint a minister from outside of the National Assembly in terms of section 91(3)(c) of the Constitution. my appointment of Professor Kachelia as a minister will be made in terms of Section 91(3)(c). This will be done in terms of President Act under this section. 53. I chose to appoint Professor Kachelia in particular because of his in-depth knowledge of and experience in the security cluster. He served as member of the executive. He explains that. I don't need to read to the court. Then he says 54. Professor Kachelia is, however, available only after his retirement from his current position on 31 July 2025. In order to ensure continuity of the portfolio of the Minister of Police, as I assign the powers and functions of this portfolio to Minister Mantashe for the period until Professor Kachelia becomes available to assume these powers and functions. I refer in this regard to Annexure AA6, be my President Act appointing Minister Mantashe as Acting Minister of Police for this purpose. You'll find that at page 161. I don't need to take the quote there. Then he says, upon his appointment as Minister, Professor Kachelia will be assigned Minister Mkunu's powers and functions as Acting Minister of Police, given Minister Mkunu's absence. And then 56, I acknowledge that the appointment of Professor Kachelia as the Acting Minister of Police, pending the outcome of the investigation by the Commission of Inquiry, has cost implications. The expenditure of additional resources for the appointment of a person from outside Cabinet could, however, only be avoided by assigning Minister Mkunu's powers and functions to an existing minister or to appoint a deputy minister as a minister to enable such assignment. So he took that into account. I'll skip 57 for the moment because that is where the controversy arises, and take the court to page 99, paragraph 102. He says, I have explained above my reasons for the appointment of Professor Kachelia as the Acting Minister of Police, as well as the provisions empowering me to do so. As I have addressed, Professor Kachelia will be appointed as a minister in terms of Section 91(3)(c) of the Constitution, and then assign the powers and functions of the Minister of Police to enable him to act in this position. So if you take the confusing sentence out, it's not clear as mud. It's very clear that the President is very aware that he has to act in writing on the 1st of August when Professor Kachelia is available, first to appoint him as minister and joins cabinet, and to assign him the powers and functions of police so that he feels what the President calls a lacuna in the police because Minister Mkunu is on leave, to act in that position for as long as the Commission of Inquiry, as long as he requires the outcome of the Commission of Inquiry to make a decision on whether to dismiss Minister Mkunu or not. And the fate of Professor Kachelia obviously depends on the President. He might think he has performed so well, he must stay there. Minister Mkunu comes back but gets water and sanitation or some other portfolio. All of that is in the discretion of the minister. Minister Mkunu is an adaptable minister. He's served in various portfolios. It's a serious matter that I'm making. At paragraph 57 then, to the controversial sentence, he says, I have outlined above the reasons why, given the nature and seriousness of the allegations against Mr. Mkunu, I have elected to appoint an acting Minister of Police from outside Cabinet, as I'm entitled to, and I've mentioned the sections. But he invites the court, he invites the reader of this affidavit, when you read 57, to read back. And reading back, you see the clarity that I just submitted. And after that, he carries on. Furthermore, Professor Kachelia is meant to hold this position for the duration of the Commission of Inquiry, which is intended to complete its work with the urgency that it deserves and in a maximum of 6 months. It was based on these considerations that, mindful of the expenditure associated with the appointment of Professor Kachelia, I deemed this expenditure justifiable in the circumstances to maintain the legitimacy and integrity of the criminal justice system. I'm advised that this is a judgment that falls in the heartland of executive functions. It involves a value judgment balancing competing interests over which reasonable people may differ. The parties here show you that. But that reasonable people may differ is not a basis for this court to interfere. So the point, really, the simple point is, in the first instance, when the court asks itself, can Professor Kachelia take up a position on the 1st of August under the Constitution? if objectively he can, there's nothing to invalidate because he is not in that position yet. The announcement of the president is nothing more than I've identified this person to be the one who's going to act as the Minister of Police. But the appointment itself, which is the act which is taken under the Constitution, has not yet happened. If it doesn't happen, this all is academic. If it happens on the 1st, it happens consistently with the Constitution. This, with respect, is the worst of the challenge, must rank as the worst of the challenges. Because former President Zuma knows how you appoint ministers. You do so by President Act, because Section 101 of the Constitution says so. He knows the empowering provisions, and he can read the affidavit, and it's very clear. Other than with great respect to my learned friend, you don't read an affidavit that way. You don't read one sentence and say, even when the paragraph invites you to read back, you just read one sentence and say, well, this is the height of irrationality. It's not.
Thank you, thank you. Justice Majid.
Just on this question of the appointment of Professor Kachalia, Mr. Maneche, is there room to read Section 91.3, Section 91.2, the President appoints the Deputy President and Minister and assigns their powers and functions as one continuous act. In other words, you appoint the Minister and immediately assign the functions, because Mr. Mpofu argues the alternative to that is a Minister without portfolio, which is unknown in our system, he says. Is there room for that argument?
No, there's nothing in the Constitution which says that's one transaction. It's very conceivable that the President can appoint and then assign functions. There's nothing wrong in that.
If he appoints Professor Kachalia, just for argument's sake, on the 1st of August, Minister of Police, can that happen sort of in one flourish, in one presidential act? In other words, he says, I hereby appoint Farouz so-and-so Kachalia as Minister of Police. Can he do that? In terms of the
Justice Majid, yes, he can. He can say, in the same presidential act, I appoint,
sorry, I was just clarify something, not as Minister of Police, as
acting minister. He can say, I appoint Professor Kachalia as minister, and I will assign the powers of police, or I'll assign to him the powers of police, and he gets sworn in. But it'll be so in the way the question is put is a simultaneous act, but in effect it's sequential, even though it appears in one paper. It may be on the same day that he gives him the first appointment, and the same day he gives him the second appointment, the second assignment of functions and power.
You see, that's what bothers me. You can't appoint an outsider as an acting minister. We know that.
Yes,
so
yes.
So how he purports to do this, or plans to do, let me not say purports, that sounds a bit harsh, plans to do this, is to appoint him a minister, and it must be thereafter appoint him an acting minister. Now, let's say the presidential acts are two of them, separated within an hour. 10 o'clock a minister, and at 11 o'clock an acting minister.
Yes.
That hour or so is a minister without portfolio. Not so. I mean, they're not splitting hairs because this is important constitutional principles.
So let's just pause for a moment. So we would submit that there's nothing in the Constitution which says there cannot be a moment in time when there is a minister without an assigned function. Because there may be instances where he's got an existing minister, existing cabinet minister, but he's considering reassigning that minister, but hasn't yet made the decision finally on which portfolio he's going to assign that minister. On the argument that you can never have any moment in time, fleeting moment, when a minister is without a function, it would mean for that moment that person is not a minister. So and that argument flows from this, that a minister, you can't have a minister without assigned functions. Well, portfolio is slightly misleading, because portfolio suggests you are it's police, but you could take away an aspect of the policing portfolio to give to someone else, like it happened with energy and electricity in that moment when they kind of. But generally, you don't have situations where a minister is sworn in and you don't know yet what the portfolio is. It doesn't happen. But I submit with respect that it would be the height of sophistry to say, legal sophistry to say, 10 minutes ago you were given the appointment to be minister. 10 minutes later you're given functions. There's a time when there was an invalid occupation of office or appointment. With respect, those would be, it might even be a de minimis kind of breach if there is a breach of that kind.
Just one last question. Mr. Mpofu pointed us to sections 177, 194, with this question of no express provision for suspension. And he didn't argue it, but I think the suggestion is that he cited those two examples where there's express provision for suspensions on the basis of the principle inclusio unus est exclusio alterius. That's what the implication is. What do you say about that argument?
There is a reason why those presumptions are only guidelines for interpretation, because there are circumstances when you depart from them. If that argument was correct, Masetla would have been decided differently, because in Masetla you had the power to appoint and you didn't have a power to dismiss. But there are many places in the Constitution, at least the one we are dealing with today, where the Constitution expressly confer a power to dismiss. Only argument is where the Constitution wants you to have a power to dismiss, it says so. You can't imply it where it is not said so. But Masetla went exactly the opposite direction. So it is simply, that expressio unius is simply a guideline for interpretation. The ultimate question that the court has to grapple with is whether we are correct to say the proper exercise of the power to dismiss implies the power to suspend, to enable a president to properly exercise the power to dismiss. And so when I argued the point, the argument we make is this, is that the president has the express power to dismiss, but that power is constrained under the Constitution. It must be exercised rationally, meaning both in respect to reason, substance, and process. When the president is confronted with allegations and he says, I can't properly inform myself whether a dismissal is appropriate, I can't properly exercise that decision rationally, because I'm not sure whether these are wild allegations or there's substance to them. If he goes ahead and dismisses, that with respect is not a proper exercise of the power to dismiss in that context, because it is either irrational for substance or maybe attacked for irrationality for process. So for the president to properly exercise that power, he must have all the powers, implied powers that enable him to exercise that power consistently with the Constitution. And that means consistently with the requirement of rationality, the requirement that he can't do so in breach of the Bill of Rights. All of those constrain that power. We're not in a prerogative. My learned friend, Mr. Katz, is 100% correct. We agree with him. This court has said so. This is not a prerogative, it's a power subject to constitutional constraints. And when one reads the reach of that power, one reads it in the context of those constraints. And that is where this power is clearly so implied. It really beggars belief that my learned friend can say, if a minister requests to be placed on special leave for any reason, because the reason doesn't matter, it could be a cancer patient, it could be an accident at work, it could also be like former Minister Kize, that there are serious allegations, please place me on leave so I can pay attention to these allegations and defend myself. Could be just a selfish reason for why he asked to be placed on leave. He says you can do it if he asks, but you can't do it if you offer it to him and he accepts and you place him on leave. That's, with respect, makes no sense. And that is in reality a concession that there is naturally a power that arises from the power to dismiss. And we've argued the power to assign and unassign powers as well as an additional point.
Just one question from my side, Mr. Maneche. Mr. Mpofu this morning, relying on Law Society, and in particular, I think paragraph 3 thereof, to the extent that he argued that public power must not only be exercised within constitutional bounds, but must also be exercised in the best interest of all our people. And he expanded on that principle, and I understood his argument to mean that when one subjects public power to scrutiny, then it would be competent for a court to decide whether the public power is exercised in the best interest of all its people, which would be a standard different from a legality standard or a rationality standard, but almost looking at the merits of the exercise of their power. What do you say to that? Do you accept that that's a legal standard, or would you say that that may be aspirational in terms of the kind of value-laden society in which we live?
Yeah, it's not a legal standard. Legality is sourced in the rule of law in Section 1C. We don't know where the public interest is sourced in as a standard. But the public interest criterion, forms part of the president's, could form part of the president's considerations when he makes the judgment call whether he must dismiss or not dismiss, for instance, in the present case. But when he's done so and he's challenged and he says, I did it in the public interest, the rationality standard will ask whether, in fact, there is a rational connection between that reason and what he's done. But it's not the court being invited to assess the exercise of the power and saying, just as a decision, first instance decision maker, is this decision in the public interest? No, that's taking over the power of the president and not assessing it for rationality.
Something that's bothering me, I just need clarity. Minister Mkhunu has been placed on special leave. He is still a member of parliament.
Yes.
Still enjoys the benefits. If, I don't know now, the maximum number of members of parliament is supposed to be 400. If that number is 400, inclusive of Minister Mkhunu, and the president appoints Professor Kashalia on the 1st of August. Professor Kashalia is supposed to be a member of cabinet and a member of parliament, isn't it? Would he not be in excess?
I'm not sure that sorry, let me just check that. Because I didn't read the constitution to require him to be a member of parliament also.
For instance, when the late Minister Pravin Gordhan was appointed as a Minister of Finance, he was from outside of Parliament. He became a member of Parliament after his appointment. So why would this be different?
Yes.
So once you're appointed as a minister from outside, you become a member of Cabinet, and we know that members of Cabinet are members of Parliament.
Yes. Can I just, so the section 91(3)(c) says he may select no more than 2 ministers from outside the assembly. And presumably he can appoint me. I'm not a member of any political party. I'm not sure how I would become a member of the National Assembly, but
he may appoint you, but there must be a vacancy inside the House for you to be a member. Otherwise, there's going to be an excess somewhere, somehow.
Yes. Well,
and if Minister Mkhunu is still there, then that is the problem.
Let's assume that to be the case. I'm not certain about the legal position, and I don't want, perhaps my learned friends here will assist me. Let's assume that to be the position. That would not be a national executive problem. It's a parliament issue to resolve. Because it is parliament that decides whether Minister Mkhunu must carry on as member of parliament despite the allegations, or what happens to him. That's an issue that is not put squarely at the at the President's responsibility under Section 91, he appoints from outside Parliament. Presumably he'll engage his party, and some other person might choose to resign from Parliament. And if we've seen it, especially with this political party.
These people doing this. Otherwise, we'll ask you to leave the courtroom.
Yes. What I'm saying, Justice Mkandla, is that it would be a Parliament issue, but there's probably scope for how political parties resolve this. We've seen parties remove people so that, as Justice Mkandla raised with Minister Gordhan, so space is made for that person to take up their position and then become a minister. There's also a possibility that those instances happen when the President has exhausted the 91(3)(c) situation, because that's limited to 2 ministers. If I recall, Minister Patel was also a minister appointed under this section. And there are many, truly, these facts are not before the court, so I'm not able to deal with them directly. But what I'm suggesting is it wouldn't impugn the appointment under 91(3)(c), because all that allows the President to do is to appoint from outside. If he hasn't exceeded the maximum, he's entitled to do so. How, after the appointment, and it will be a matter that arises after appointment, not today, as we argue the case, that issue doesn't arise yet. We don't know whether the ANC has its full complement in Parliament or not, and who else might want to step away for Professor Kachalia to take up position. We just don't know. So it wouldn't be a basis on which this court could impugn the appointment of Professor Kachalia. And it's not relied upon by the applicants. Yeah, I know, he is Justice Mkandla. I acknowledge that.
Justice Majid.
Just a quick follow-up. It's not proper for judges to answer questions from other judges, but the way I read it, 91(3)(c) is very specific and must be read with 91(3)(b). See, 91(3)(b) says he may select any number of ministers. And we know there's no cap. There's a complaint the cabinet is too big, but that's another story. Any number of members from the assembly. But the 2 he selects is from outside the assembly, and ergo, they're not going to become members of parliament.
Yes, that was my understanding.
Yes, thank you. So, Mr.
And Section 46(1) of the Constitution says...
sorry, which section?
46(1). 46(1) of the Constitution says the National Assembly consists of no fewer than 350 and no more than 400 women and men elected as members in terms of an electoral system. So if you're not elected, you can't become a member. So that would seem to be the answer. Yes, thank you. Thank you. I knew that my resourceful team would come to my rescue.
Mr. Gordhan.
I was hoping for a question on the Commission of Inquiry.
Well, there's none.
There's none.
Mr. Madonsela.
Let me just make sure that I don't leave things for Mr. Madonsela here.
Justice Mkandla and Justices of the Constitutional Court, Sunday, the 6th of July 2025, will live in memory as a day like no other day, when the Lieutenant General Mkhwanazi, the whole Provincial Commissioner of KwaZulu-Natal, pulled a surprise move without a warning shot and took to the podium and publicly indulged in a most serious attack not only to the law enforcement agencies, the prosecutorial services, intelligence services, the judiciary, all levers of power in the administration of justice. Of course, the Minister of Police himself was not spared. He was also ambushed with this media conference because he was also in Freiheit attending to his political commitments in the by-elections there. The President, too, the second respondent in this case, was in Brazil. And in the wake of these attacks on the minister and other agencies and the judiciary in particular, the MK party drew out spears, crying out, "Crucify him, crucify him." That's what they said when the president arrived. They said, "You must dismiss the minister." And in fact, in their founding papers, that's the case they made out. If you look at paragraph 25 or 52 at page 24 and 52.6, saying that the Minister Mtunu should not have been placed on leave, he should have been dismissed. That, in fact, was their demand in a letter of demand at page 44, where they said, with reference to another minister, or the Deputy Minister Whitfield, they said the President should have dismissed Minister Mtunu as he did with the Deputy Minister. So that was the case they made out. In reply, at page 236, paragraph 90, they repeated that claim. They said the minister should have been dismissed. He deserved to be dismissed, as it happened with Whitfield, at paragraph 90 of the replying affidavit. It was in this context that the President, after consultation with the Minister Mtunu, and you'll find this in the answering affidavit at page 172, paragraph 12, where the minister says that I was consulted by the President about this, and he confronted me about the allegations were made by General Mkhwanazi, and I denied wrongful conduct on my part. And that, under those circumstances, the President said, I couldn't resolve the issue. I'll place Minister Mtunu on special leave. May I just, Justice Theron, touch on the point that you raised about what is the nature of this action? Was it leave or suspension? Well, the applicant said in their founding papers, at paragraph 52.1, they said, this is just suspension by another name, a fancy name for suspension. And we embrace that characterization. And we embrace it because there is judicial support for the fact that special leave, which is consensual or under the circumstances such as the present, is nothing else but a euphemism for suspension. So when we use the word suspension of the minister, we're using it in the sense that it is a special leave which is a euphemism for suspension. And Minister Mkhunu, at paragraph 13 of his answering affidavit at page 173, accepted the decision to be placed on special leave. So it's consensual. So it doesn't matter whether it was requested or granted, but it is mutual between the two of them. So nothing turns on that point. So, my Lord, under this, Justices, under these circumstances then, we seek to engage with two issues only. Whether the President had the power, the ultra vires argument, had the power to suspend Minister Mkhunu. And in this regard, we locate that power. Or the second point that we deal with is rationality, but my learned friend has dealt with it. I'll just make a few comments in relation to it. In relation to vires, whether the minister or the President had the power, we rely, as we do in paragraph 25 of the answering affidavit at page 176, locate the power of the President to suspend on section 91(2). And we say that section 91(2) has three components. The first component is that the President can appoint at the beginning, and in the middle, he can assign. If I may pause in the middle for a moment and go to 98 and say, again in the middle, 98 tells us that he can also reassign the functions if the cabinet minister is temporarily out of action or is absent, temporarily absent. And at the end, the third component, he may dismiss. Those are the three parts of 91.2. Now the argument today is that, well, because those three parts of 91.2 did not contain the word suspend, therefore it cannot be, it's not an express power or it's not implied power. Well, we assume that our premise for the argument is that, yes, there is no express power, but there is an implied power. And we have placed reliance in the judgment of Amapungane in this regard, which is set out at page 50 of our heads of argument. And Justice Kolapen, you're right when you referred our learned friend in this regard to the judgment, to the quotation in Baxter in Amapungane, where the court said an implied power can be power that is reasonably required in order to exercise the original power. It can also be an ancillary power. It can also be an incidental power. So when you imply powers, you imply those that are ancillary, incidental, or reasonably required. And that's the quotation from Baxter is set out at page 21 of our heads of argument, paragraph 60. And it's also referenced in Amapungane itself. So we say in this regard that the implied power to dismiss is an ancillary power, to suspend is an ancillary power to dismiss. And in this particular context, it is necessary to preserve the integrity of the investigations which the President has put and set in motion. And the President explains this in the answering affidavit at paragraph 40 at page 85, where he says he wanted to ensure that there is no interference by the Minister on the investigations of the contested allegations that General Mkhwanazi made in that dramatic media conference. So the power, Justices, is implied, is there. It is implied, it is necessary and required in order to exercise the determination on whether or not, subject to the outcome of the investigation, Minister Mtunu should be suspended or should be dismissed or should be retained. So that is the necessity of the power. So, my Lord, we say that in support of this implied power, there is both judicial and academic support for the proposition of an implied power. Insofar as judicial support is concerned, we place reliance in the judgment of Mphehle, which is referenced at paragraph 61 of our heads of argument, page 24. It's Mphehle versus the government of the Republic of South Africa. Now, my learned friend says, well, this judgment is not on point for the reasons I'll deal with in a moment, but here is the reasoning of the judgment. Here is the reasoning of the judgment at page 930 of the judgment itself. Now, this is a case involving the Premier of the Eastern Cape suspending the MEC, and we say that is comparable with the President suspending the Minister, said that the other one is in another sphere of government. In relation to the issue of suspension, the judgment says, judgment of Heath, I agree with the principles referred to by Madlanga. Mr. Madlanga was then counsel and is now the commission in the Madlanga Commission. But then he says, however, the Constitution itself already makes provision for the termination of membership of a member of the Executive Council, which is much more far-reaching than a suspension, and effect must be given to the Constitution as far as the power is concerned. In other words, it says there is power to terminate, but there is no power to suspend. But termination is far more far-reaching than suspension. And then at the end, in the next paragraph, marginal letter D says, on the one hand, a suspension is a well-known interim position or a step or a phase leading to a termination or dismissal, and a suspension in the present instance is clearly a logical and necessary consequence of the powers conferred on the Premier. The logic of the greater, including the lesser, therefore applies. In other words, it says, if you have got the powers that are greater to dismiss or terminate, that includes the power that is far lesser, the power to suspend. There is authority for that proposition. So my learned friend says, well, the problem is that the Constitution as it now stands, it gives it in Chapter 5, delineates instances where the power, or the acting powers can, in Chapter 5, there will be powers that are acting for acting president as distinguished from the powers, the absence of the powers of the ministers to act. Well, my lord, there is a short answer to that argument. The reason why there is a different section for acting president is that in this country there can only be one president. Not many, unlike the ministers who can be many. But the second distinction is that Chapter 5 analogy is unavailing, because in Chapter 5 you will see, when you read the schedule for the oath of office of the president, that it is different from the oath of office taken by the ministers. So there has to be a separate system regulating acting president, as opposed to a system regulating ministers. So the point is, the Chapter 5 argument that there can be nothing in between, because Chapter 5 separates or provides specifically for acting president and not necessarily for acting ministers, is unavailing. So, my lord, apart from the judicial support, there is also academic support for the proposition that the power to suspend a minister is inherent or ancillary to the power to dismiss. You'll find this in Closer, in Chapter 18, at page 29, which is referenced paragraph 60 of our heads of argument, where the learned authors of Closer say that the power to suspend is an incident of the power to dismiss. So we both have academic as well as judicial support for the proposition that the power to suspend is there in Section 91(2). But there is another reason why the power is there, and it's Section 98 of the Constitution, which says that the power to assign functions of one cabinet member to another during the latter's absence is implied by the president. So, Justices, you will see that Section 98 says, during the absence of one of the cabinet members, the president may assign a function to another cabinet member. Now, the fact that he can assign in the absence of another cabinet member means that there is implied provision that he can create a vacancy and excuse a minister from being present in order to assign another minister. Especially dealing with a particular scenario where that minister is temporarily absent, not because he is not around or he's been reassigned to another post, simply because he's temporarily absent. So if the power to assign a minister during the temporary absence of another minister is catered for in Section 98, that implies that he has the power to create a situation, to allow a minister to be away for purposes of reassignment of another minister. So it is an implied power set out in Section 98. So on those two provisions, we say that there is clear authority for the proposition that the power to suspend is implied from both Section 98, 91(2), as well as buttressed by Section 98, which provides for the power to assign during the temporary absence of a cabinet member. Well, there was some mention in the argument by our little friend, Mr. Mpofu, about the relevance of the Mwabe judgment that the president publicized in a media statement that he was going to appoint Professor Kachale. Now, I was part of Mwabe in this court, and Mwabe is no authority for the proposition that a public announcement alone achieves finality in the decision. I know so because if today Kachala was to approach this court and say to this court, please give me the position that you announced to me because you announced it, he will not get it. That was the result of Mwabe. And finality is achieved, contrary to what Balel friend says. Finality is achieved, and this is set out in paragraph 56 of the judgment, not after public notification, but after personal notification, through a minute by the President, concluded and entered in terms of Section 101 of the Constitution. So Mwabe does not assist them to say that there is a problem with the appointment of Professor Kachala. That was just a passing comment in relation to Kachala because that's not my argument. My argument is on there is power to appoint or to suspend a minister. Now, that concludes the argument on ultra vires. On rationality, my little friend has really made the point. I want to make a few points on it. The test is well known in the Mendes Milana case, set out in paragraph 65 of our heads. The question is whether the exercise of power, that is the power to suspend, is rationally connected with the purpose for which the power was conferred, and the purpose is to assign powers. Now, the justification for the suspension is set out by the President in paragraph 40 to 42, and there are 4 reasons why the President adopted the route of suspension. He says in those paragraphs, 1, it was because of the seriousness of the allegations by Lieutenant Mkhwanazi, whether Mkhunu was engaged in criminal activities. That was the first reason. Secondly, the allegations had profound implications for public confidence in the executive. Thirdly, the need for proper investigation into the veracity of the allegations through a judicial commission of inquiry. Fourthly, that the decision to dismiss Minister Mkhunu was going to set a bad precedent which would be created if the minister was to be dismissed on mere allegations which can turn out to be unfounded at the end. So these are rational reasons we submit, Justices, which led the President to take the decision to suspend rather than to dismiss. And the context is that he had consulted the Minister of Police, our client, and those allegations about him were denied and had to be investigated, as are the allegations that the judiciary was also was implicated in cartels, drug cartels, as are the allegations that the law enforcement agencies are infiltrated, and as are the allegations that there is interference by the minister with the workings of the political task team. So the rationality, my lord, the rationality threshold is met in the reasons advanced by the President, and the rationality is not really about the questions which the other applicants are raising, whether it is appropriate to take that decision, whether it is reasonable to take that decision, whether there are other available options, and we have set out why those considerations do not apply here. And if this court is with us on those rationality arguments, and therefore the application should be dismissed.
Mr. Madonsela, any questions? Looks like there are no questions for you, Mr. Madonsela. Thank you. I think you should run before colleagues change their mind. Mr. Mpofu, tell us.
Living in leave of absence. I'm taking leave of absence. Thank you, Justices. Maybe let me. Well, first, the deal that we discussed with Mr. Katz is on.
The 5 minutes.
No, all of it, the 10.
Whole.
10 plus 10.
So it's 20 minutes.
Yes. Thank you.
You confirm that, Mr. Katz? Thank you. 20 minutes.
Thank you. So, okay, so I'm going to make sure I've got, let me take off my watch. Oh, there you go. Thanks. Yeah. So that at least by the time that 20 minutes elapses, I must have said everything I want to say. Let me do this, Justices. I'm going to resist the temptation to start with the point that was donated by Mr. Madonsela based on Mngcwabe. Tempting as it might be, because I want to approach my argument differently this time in reply. We, and when I say we, I mean respectfully, I'm including the court, discussed in detail the issue of implied power, and vires and all that. But in my respectful submission, we did not deal with the rationality issue sufficiently. So with the leave of the court, I'll start with rationality this time, so that even if I run out of time, then on implied powers and vires, then and at the back of what I'm going to say, also which might also save us time if we do reach the issue of implied power, is what I said in response to Justice Rogers, which is that there's a clear overlap between the so-called necessity test and the rationality test in the manner that I've explained. So let's go to rationality. And as I say, whenever I deal with this, let's also keep in mind this question of necessity. So what do we have here? Mr. Manecha is really telling us this, that the decision to place on leave of absence is rational or rationally connected and linked to the stated purpose. Remember, what is the stated purpose? The generous one that I'm going to grant them. The stated purpose is that this is leave of absence, suspension, call it whatever, pending the outcome of the commission. Right? Now, I'm going to demonstrate the fallacy of that argument, to show that there is no rational connection conceivable between the leave of absence and the outcome of the commission. We have evidence, live evidence, that this president will, irrespective of the outcome of a commission, will not only appoint you to be a minister, but actually promote you if there's an opportunity for doing so. Let me explain. Because for that argument to hold, it must be that really the president is saying, I don't know about these allegations. I must await the Madlanga Commission. If it says there's prima facie evidence, then I may dismiss. We must believe that story. Well, that story, there's no South African, nobody who lives in this country who can believe that story. No one. Because, and the president says, the reason why I'm taking all the steps is because the allegations are untested. So they'll be tested where? In the Madlanga Commission. But that is a fallacy. Because when the allegations against certain ministers were tested, and this is in our replying papers, those allegations were now tested in the Zondo Commission. And those ministers were said to be prima facie criminally liable. The thing that he says he's waiting for in relation to Minister Mchunu, when that happened, the president appointed those people to be cabinet ministers. And the live example of that is none other than Minister Gwede Mantashe. Let's call it the Mantashe test. The president, to sustain that argument, would have to pass the Mantashe test. And he fails it dismally. Because, as we speak now, today, despite the tested allegations that were in the Zondo Commission, what did the president do? He has appointed Minister Mantashe as acting Minister of Police now, today, as we speak. What does that mean? It means if Minister Mchunu were to be placed in the same position as Minister Mantashe in 3 years' time, after the Madlanga Commission finishes its work and the review applications and the appeals and all that happens, then we would have, let's assume then the Madlanga Commission says Minister Mchunu has prima facie criminality and so on. So he would be in the exact same position as Minister Mantashe now. And we have had evidence that that would mean he would be qualified. In fact, not only has Minister Mantashe been appointed as Minister of Minerals and Energy, and now appointed as acting Minister of Police, he has even been promoted to acting president recently. So if you do wrong and you are found by a commission to have possible criminal liability, not only are you not going to be punished, but you are going to be promoted, probably. What is that? We cannot, this president, I know he can do no wrong, is the super saint. But there has to come a time in this country where we must say, this far and no more. You cannot have a president who's going to come to this court and say, in open court, daylight, I am waiting for these things to be tested so that I can possibly dismiss. When all the evidence shows that with Minister Mantashe, with Zizi Kodwa, with Deputy Minister Mahlobo, all the people who were implicated in the Zondo Commission have been appointed by him. Now, he says the allegations are untested. Well, all of us would love to be in this university where you can't fail. You can't fail the test. Because the more you fail the test, the more you're going to graduate. And we call that rational? That we are all, the whole country must wait for 3 years and spend 2 billion rand to get to a stage where nothing is going to be done. Or if something is going to be done, it's probably going to be a promotion of Minister Mchunu. That is the reality. That is how we must approach the rationality test in this case. Now, once you remove the facade of the artificial connection between the outcomes of the Madlanga Commission and the so-called leave of absence, then its rationality goes to the dustbin. It is simply an excuse to make sure that Minister Mchunu continues to have his salary. Mr. Katz put it properly. The only purpose, I'm inviting anybody to think of any other purpose that is going to be served by the leave of absence, apart from making sure that Minister Mchunu retains his salary. What is it? There isn't. And that can never be a rational purpose for exercising presidential powers in any country. Now, Mr. Mainache tells us about he dealt with the rationality. I think one of the justices asked the question about the dismissal or non-dismissal. Let me put it like this. We all accept, just so that I'm not misunderstood, we all accept that generally speaking, the rationality test is not what one of the parties, I can't remember which one, accused us wrongly. It's not a whataboutism. So you don't say, okay, well, I suspect it was Mr. Madonsela. You don't say that, well, you placed him on leave. Why did you not dismiss him? In general, you don't do that because it has been said many times in pharmaceuticals, in Albert, in all the cases. But this is not, when we talk about the dismissal of Minister Mchunu in this particular case on these facts, it's not in that mold. Their own version is that this power to place on leave of absence is derived from the power to dismiss. Right? That therefore means in this, on their formulation, you can never take the decision to give leave of absence without having first considered the decision to dismiss and discarded it. So it's not the whataboutism mold. It is to say, because you are saying that power is, someone was even saying a lesser power or whatever. But its parentage, its ancestry is the power to dismiss. So before you do leave of absence, you must have at least taken a decision to retain or a decision not to dismiss. And it is in that context that we say that prior decision is about the breaking of the egg and the omelette. That prior decision not to dismiss was in its own right irrational as well. But if its corollary, to quote my learned friend, is to retain. The president would have been within his right, by the way, and I said this earlier in my address, to retain, to say, after the discussion apparently, to say, yeah, okay, from what you're saying, I'm keeping the minister and I'll wait for the outcome. And if he's found to have done something wrong, I'll dismiss him or whatever. He could do that. That would have been irrational. It would have been not a nice decision. Many people would be aggrieved. But on the rationality test, he would be prepared to do it. Now we're told by the president that there's no such thing as the prerogative. Latching on Mr. Katz's, shall we say, overstatement. I'm trying to, because he's on my side, to make sure that I don't. We know this thing about the prerogative is actually very simple. Hugo gets abused, and I probably am guilty of this as well in other instances. Hugo simply says that we don't have the royal prerogative. Everyone knows that. But we have what is called, what I call, and it's actually my own term, yeah, I call it the qualified prerogative. In other words, you still have to pass the rationality test. But there are powers that are the sole preserve of the president. But what is really said is the president who can speak with both sides of his mouth and comes here via his counsel to say there's no such thing as a prerogative. But if you go to page 159, that's annexure, annexure AAA5. You hear, it says, the heading, statement by President Cyril Ramaphosa on the removal of Deputy Minister Whitfield. So this is his own statement, the same as when his counsel speaks for him. It says at paragraph 160, after he criticizes, well, first of all, he starts with in this court he makes the false statement that Mr. Whitfield admitted his transgression. That's false. There's no nice way of putting it. Because in his own statement, he says Mr. Whitfield and Mr. Steenhuisen were distorting the facts and what have you. So if they admitted guilt, what is it that they were distorting? But that's not even the point. The point is that he says at paragraph 1234 on page 60, given all these circumstances, there is consequently no reasonable grounds for Mr. Steenhuisen and the Democratic Alliance to issue ultimatums and threats when the President exercises his constitutional prerogative and responsibility. This is the person an hour ago who said there's no prerogative. And then further down, it says, it is unprecedented, this is now President Ramaphosa speaking, it is unprecedented in the history of our democracy that the exercise by the President of his constitutional prerogative and responsibility with respect to a clear violation of the rules and so on and so on. So when it suits the President, there is a prerogative. When the shoe pinches, there's no such thing. And just for the sake of completion, page 259, there's an interview done by the spokesperson of President, who was in the position of Mr. Manecha, also speaking for the President. He says at 259, he's asked by Ms. Naledi Moleo of Newsroom. I think the big question is what do you call the straw broke the camel's back? Was it Friday when the minister filling out account before the portfolio committee and so on? It says, well, the people can opine, and when the president can exercise his prerogative, and when can the president exercise his decision? But I think a couple of factors, and further down says the second thing, even in the exercise of the prerogative, anyway, the point is made. The point is simply that everyone knows that when we say the prerogative, and to the credit at least of the president, we all know that means what I call the qualified one, where rationality is at play. But now those statements are being disowned. Now, if there's one thing I have to say is this: the use of the word dismiss in this context, not the use, because it is what it is in the Constitution, but the flawed understanding of that word dismiss is what is really at the center of this case. Because everybody, all of us as lawyers, I suppose, instinctively, when we talk about dismiss, we think about the dismissal of an employee, dismissal of a school principal, and so on. But this is not a dismissal of that kind. This is a removal. This is a withdrawal of someone from the cabinet. And that is why the section on this, section 192, section 92 that we all been talking about, 91(3)(c), sorry, uses the word select. Right? So, the power to appoint, obviously, that's the formality. But this language is used advisedly. 91(3), the president must select the deputy president. The president may select any number of ministers, and the president may select no more than 2 ministers from outside the assembly. So what is happening when you, quote-unquote, dismiss a minister is not all these big things about you must prove a case and what if they... It's just a simple matter of deselecting. You are simply deselecting that person. You are not punishing them. You are not impeaching them. You are not doing anything. Just as when you select them, they don't say, well, there should have been an advert in the newspaper, and there should have been a shortlisting and an interview. No, you select them. And just as you must select them easily without having the formalities of employment, you may equally deselect them. And that, yes. So that is those are the points that I want to make without interruption.
So that's it, Mr. Mpofu.
Well,
unless there are questions.
Unless
there are questions,
yes.
Mr. Mpofu.
Well, I wanted to deal with the question of the commission, but just because my learned friends were asked on it, but it's fine. I'll
hope. If you can only hope if there are questions, hopefully you can respond. But it doesn't look like there are any. So that will be the end of the matter. Thank you, Mr. Mpofu.
Going.
Going, Mr. Mpofu.
Going. Well, thank you, Justices. No, I know that I speak for all my learned friends when we are saying we are indebted to the court. And we also understand that we all have to be somewhere else just now. And therefore, any of the issues that I did not deal with in reply were covered in our heads as the court pleases. We're indebted to the court.
Thank you very much. Thank you to the colleagues. We need to consider this matter. We are aware of the time constraints. We are going to reserve our decision. I'm saying decision. And we are going to notify the parties as soon as possible as to whatever decision that we are going to take.
Yes.
But it's not going to be today. We can't do it now.
Justice, I understand, Justice Clark. If you just give me half a second. I can't remember what prayer it is, but in the notice of motion, we've catered, we do understand the matter is quite complex. So we made provisions for a situation where the court might reserve judgment. And I won't take it further than what is stated in the notice of motion and in the founding affidavit as to what interim measures could be taken. I'll just leave it in the hands of the court.
Reserves its decision. Court adjourns.
As court please.
We can't found the commission, they refused to ask the questions.